environmental controls, and major environmental laws. In the previous sections, you learned how public and private land use controls, zoning, deed restrictions, CC&Rs, and HOA rules shape where and how land can be used. Environmental controls add another crucial layer. Even when a property is zoned correctly and complies with private restrictions, it may still be affected by contamination in the soil, groundwater, air, or building materials. To protect public health, preserve natural resources, and keep real estate markets stable, federal and state governments have built a comprehensive framework of environmental laws and cleanup programs that every real estate professional must understand at a basic level. Soil, groundwater, and drinking water are especially vulnerable. They can be polluted by leaking landfills, improper dumping, agricultural runoff, industrial discharge into waterways, spills along highways and rail lines, emissions from factories and vehicles, and leaks from underground storage tanks that contain fuel or chemicals. When contamination occurs, it does not stay neatly within property lines. It migrates through soil, surface water, and groundwater, often affecting multiple properties and entire neighborhoods. Among the many substances that can trigger environmental controls are dioxins, produced during manufacturing or incineration involving chlorine, heavy metals such as lead and mercury, gasoline additives like MTBE, methyl tertiary butyl ether, and PCBs, polychlorinated biphenyls, that were once widely used for electrical insulation. Since 1984, underground storage tanks, often called USTS, have been regulated because their leaks can release fuel or solvents into soil and groundwater. Wetlands are also heavily regulated because they function as natural filters and wildlife habitat, so their development and use are tightly restricted. Beyond chemical contaminants, other environmental conditions are also regulated. Electromagnetic fields, EMFs, from high-voltage power lines raise health and perception concerns. Noise from airports, rail lines, and freeways affects livability and can influence land use planning and property value. Properties in recognized earthquake or flood hazard zones must meet special building standards and may face stricter insurance and lending requirements. To help organize these topics, you will often see environmental concerns summarized in acronym form: BRI for building-related illness, SBS for sick building syndrome, VOC for volatile organic compound, MTBE for the fuel additive methyl tertiary butyl ether, PCB for polychlorinated biphenyl, UST for underground storage tank, EMF for electromagnetic field, and UFFI for urea formaldehyde foam insulation. Each represents a type of condition or substance that may affect buildings, occupants, or the environment, and may trigger disclosure duties or specialized inspections in a real estate transaction. The rise of modern environmental legislation. For most of American history, there were few effective controls on pollution. Industrialization in the mid-1900s brought economic growth but also dirty air, rivers that could catch fire, and widespread dumping of waste on land and into waterways. By the 1960s and 1970s, environmentalism had emerged as a political and social movement, pushing government to acknowledge that clean air and clean water are not luxuries but necessities for public health. Environmental legislation is the collection of laws and regulations that deal with air quality, water quality, wilderness protection, endangered wildlife, toxic substances, and related issues. Although each law focuses on its own area, together they share one goal: regulating the interaction between human activity and the natural environment to reduce threats to both public health and ecosystems. A classic example involves an energy company wanting to build a coal-fired power plant. Environmental law asks where the plant should be located, what pollutants it will emit, what technology must be used to control those emissions, how nearby residents, human and wildlife, will be affected, and whether there are alternative sites or cleaner options. The answers are not purely technical questions. They are framed and constrained by environmental statutes and regulations, NEPA, and environmental impact statements. The modern era of environmental law in the United States is often dated to the late 1960s. A key turning point was the National Environmental Policy Act, NEPA, of 1969. NEPA created a national policy that federal agencies must consider environmental factors when making major decisions. It did not ban pollution outright, but it changed how big projects are evaluated and approved. One of NEPA's core tools is the Environmental Impact Statement, EIS. When a proposed federal action, such as building a highway, dam, or power plant, may significantly affect the environment, the responsible agency must prepare an EIS that analyzes the project's likely environmental impacts, considers alternatives, and discloses this information to decision makers and the public. Without an adequate EIS, major projects can be delayed or blocked. NEPA therefore forces environmental concerns onto the same table as engineering, cost, and politics. Clean Air Act 1 of the earliest and most important follow-up statutes is the Clean Air Act. Before it, many American cities were shrouded in smog from cars, factories, and power plants. The Clean Air Act, first passed in 1963 and significantly strengthened in 1970 and 1990, gives the Environmental Protection Agency, EPA, authority to set national air quality standards and limits on major pollutants from industrial sources and vehicles. Under the Act, the EPA sets maximum acceptable levels for common pollutants such as ozone, particulate matter, sulfur dioxide, nitrogen oxides, carbon monoxide, and lead. States then design implementation plans to meet these standards. If a factory or power plant emits too many pollutants, it must upgrade pollution controls or face enforcement actions and fines. Over time, this law has dramatically reduced many forms of air pollution, preventing millions of asthma attacks, respiratory illnesses, and premature deaths. For real estate, the Clean Air Act matters because it can affect land use. For example, where certain industrial facilities may locate, influence development along busy transportation corridors, and drive demand for cleaner building systems and technologies. Clean Water Act and Safe Drinking Water Act. Water quality is governed by two major federal laws with different but complementary roles. The Clean Water Act of 1972 focuses on pollution in surface waters, such as rivers, lakes, streams, and oceans. It primarily targets pollution from point sources, identifiable discharge points, such as pipes from industrial plants or sewage treatment facilities. It requires permits for discharges, sets water quality standards, and provides funding to build or upgrade sewage treatment plants. Famous pollution events like repeated fires on the Cuyahoga River helped spur passage of this law. For real estate, the Act affects what can be discharged on or near a property and restricts certain activities in wetlands and other protected waters. The Safe Drinking Water Act of 1974 addresses water safety at the tap. It sets enforceable standards for contaminants in public drinking water systems. And after 1996 amendments, focuses on protecting water supplies at their source as well as at the tap. While it does not apply to private wells, it covers virtually every public water system and regulates pollutants such as bacteria, nitrates, heavy metals, and pesticides. This law reassures buyers that when they turn on a faucet connected to a regulated public system, basic health standards must be met. Waste management, CERCLA, and Superfund pollution is not just about emissions into air and water. It also involves where and how solid and hazardous waste is stored and disposed of. Several key laws address these issues. The Resource Recovery Act of 1970 and the Resource Conservation and Recovery Act, RCRA, of 1976 regulate the handling and disposal of solid and hazardous waste. They emphasize tracking hazardous wastes from cradle to grave, meaning from generation through transportation, treatment, storage, and final disposal. Proper permitting and facility management are required to reduce the risk of leaks and illegal dumping. Even with these laws, thousands of sites had already been contaminated by hazardous substances. To address these, Congress passed the Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA, in 1980, commonly called Superfund. CERCLA created a federal program to identify, prioritize, and clean up the nation's most hazardous waste sites. It also established a process for identifying potentially responsible parties, PRPs, and holding them liable for cleanup costs. Tax revenue collected mainly from chemical and petroleum industries went into a special trust fund, the Superfund, to pay for cleanup if no responsible party could be identified or if they were unable to pay. A property's location on or near a Superfund site is a material fact in a real estate transaction and must be disclosed because it can affect value, financing, insurability, and buyer willingness. In 2002, the Brownfields Revitalization Act amended CERCLA to encourage cleanup and redevelopment of contaminated but underused properties, known as brownfields. These are often old industrial or commercial sites in urban areas where real or perceived contamination discouraged investment. The Brownfields program provides funding, liability protections, and tax incentives to make it more feasible to clean up and reuse these properties instead of developing pristine greenfield land. SARA and Innocent Landowner Immunity. The Superfund Amendments and Reauthorization Act, SARA, in 1986 strengthened CERCLA by setting stricter cleanup standards, emphasizing permanent remedies, and encouraging new treatment technologies instead of simply containing waste. SARA also clarified liability rules and introduced the concept of innocent landowner immunity. Under CERCLA and SARA, current landowners can be held liable for cleaning up contamination on their property and even on neighboring property impacted by that contamination, regardless of who originally caused the problem. This potentially harsh rule is why environmental due diligence is so important in real estate. SARA provides a limited shield for buyers who truly did not know about pre-existing contamination and who performed appropriate due diligence before acquiring the property, typically in the form of an environmental site assessment. However, if a buyer discovers contamination during due diligence but proceeds anyway, they cannot claim innocent landowner status later. Lead-based paint, pesticides, and landfills. In housing, one of the most important federal rules is the ban on lead-based paint in residential use, beginning in 1978, and the Residential Lead-Based Paint Hazard Reduction Act of 1992 and 1996. These regulations did two key things. They banned lead in new residential paint, and they created mandatory disclosure rules for existing properties built before 1978. Sellers and landlords must disclose known lead-based paint hazards and provide buyers or tenants with an EPA-approved pamphlet entitled Protect Your Family from Lead in Your Home. Buyers must be given an opportunity, usually 10 days, to conduct a lead inspection or risk assessment if they wish. Pesticides are another concern. Agricultural fields, golf courses, and heavily landscaped properties may have soil and groundwater that retain chemical residues for many years. Pesticide exposure has been linked to serious health effects, including diseases such as Parkinson's. Properties converted from former agricultural use to residential subdivisions may carry residual pesticides in soil. Licensees and sellers are expected to exercise due diligence by asking the right questions, reviewing available records, and disclosing known conditions or risks, especially when properties are near farms, orchards, golf courses, or large landscaped areas. Landfills also create environmental and market concerns. A landfill is an engineered disposal site where waste is layered and compacted. The bottom is lined to reduce leakage, and the top is capped with soil and vegetation. While capped landfills can be reused, for example, as parks or golf courses, Properties located near active or former landfills may face odors, methane gas migration, truck traffic, and stigma. A home located near a landfill is a material fact that must be disclosed. Buyers may wish to investigate methane venting systems, liner integrity, groundwater monitoring, and reuse history, on-site wastewater and septic systems. Beyond large industrial issues, individual properties can have their own environmental risks, especially related to wastewater disposal. Most homes either connect to a municipal sewer system or use an on-site system, such as a septic tank and leach field. A municipal system routes wastewater through underground pipes to a central treatment facility. A septic system treats wastewater on-site in a buried tank and disperses partially treated effluent through a soil absorption leach field. Older properties may still rely on cesspools or other outdated systems. If a septic system is poorly designed, undersized, or failing, it can leak untreated sewage into groundwater or nearby wells. For this reason, sellers are generally required to disclose the presence of septic or alternative systems, and in many jurisdictions, to have them inspected and pumped within a certain period before transfer of ownership. In Arizona, for example, any property with a septic system in use must have the system inspected within 6 months of transfer. The inspection typically includes pumping the tank, checking baffles and tank integrity, evaluating the leach field, and issuing a report or certification. If repairs are needed, they must be completed and re-inspected before the transfer can be finalized. Underground storage tanks, USTS. Underground storage tanks represent another major source of contamination risk. Under Arizona law, a UST is a tank and it's connected underground piping, where at least 10% of the total volume is below ground, and which stores petroleum or certain hazardous substances. Typical UST owners include gas stations, convenience stores, fleet operators, and local governments. Not every buried tank qualifies as a regulated UST. Exclusions include small farm or residential tanks under 1,100 gallons used for non-commercial motor fuel, tanks storing heating oil for on-site use, septic tanks, regulated pipelines, certain process tanks, stormwater or wastewater collection systems, and tanks located in basements or similar structures where the tank itself sits above the floor surface. A leaking UST is one that has released a regulated substance into the environment. Even if the leak has been repaired, the site may still be designated as a leaking UST site because contamination remains in soil or groundwater and requires investigation and cleanup. Such leaks can create explosion hazards, contaminate drinking water, and generate long-term cleanup costs. When a release is discovered, the owner or operator must report it to the appropriate environmental agency, such as ADEQ in Arizona. Address immediate risks, investigate the extent of contamination, and implement corrective action. UST programs typically combine technical oversight, regulatory enforcement, and financial assistance to help owners prevent and remediate leaks. Licensee responsibilities and due diligence. Real estate licensees are not expected to be environmental engineers or lawyers, but they are expected to recognize red flags, know when an environmental issue might exist, and guide clients toward qualified professionals. Environmental hazards must be treated like any other material fact. They must be disclosed when known or reasonably discoverable. The Lead-Based Paint Act of 1992 and later regulations require sellers and licensees involved with residential properties built before 1978 to provide buyers with the EPA HUD Consumer Product Safety Commission booklet, Protect Your Family from Lead in Your Home. Disclose known lead hazards and allow buyers a time window for lead inspections. Under CERCLA and SARA, both current and past owners can be held liable for contamination, and in some cases, other parties such as lenders, builders, developers, and even real estate agents may face claims for failure to disclose or for misrepresentation. To reduce risk, licensees should be alert to signs such as stained soil, chemical odors, evidence of old tanks, industrial uses nearby, or knowledge of prior spills or remediation. They should advise clients to consult environmental professionals when appropriate and document their recommendations. Wheel title. Licensed should be careful to be aware of potential hazards, disclose known material facts, distribute the HUD booklet and know where to. Phrase seek professional help. For more information, licensees can consult EPA resources on asbestos, carbon monoxide, formaldehyde, lead, mold, radon, and CERCLA. While the EPA does not completely ban asbestos, it is tightly regulated under the Clean Air Act and the Toxic Substances Control Act, and many uses have been phased out. Staying current on these resources helps practitioners answer basic questions and know when to refer clients for expert advice. Closing remarks. Environmental controls remind us that real estate exists within a larger natural system. Contaminants do not respect property lines, and environmental laws are designed to protect both people and the land we rely on. For you as a real estate professional, the key is not to memorize every statute, but to understand the major themes. Contamination can trigger strict liability. Due diligence and disclosure are critical, and federal and state environmental laws shape how land can be used, developed, and financed. When you recognize a potential issue, whether it is a former gas station with USTs, a home near a landfill, a property in a floodplain, or a house built before 1978, you know to slow down, investigate, disclose, and involve experts. That approach protects your clients, your license, and the community. Discussion: how might a leaking UST at a nearby gas station affect a residential subdivision? And what steps should a buyer's agent recommend? Answer: contamination can migrate into groundwater that supplies wells or into soil under homes, potentially affecting health and property value. The agent should recommend reviewing environmental records, contacting the appropriate regulatory agency, and possibly ordering an environmental site assessment or water testing before proceeding. Why is it important for real estate professionals to understand the difference between the Clean Water Act and the Safe Drinking Water Act? Answer: the Clean Water Act regulates pollution entering rivers, lakes, and oceans, while the Safe Drinking Water Act protects public drinking water supplies and groundwater. Knowing the distinction helps licensees explain why one law affects discharges and wetlands, while the other focuses on tap water safety and public water systems. How does the concept of innocent landowner immunity change the way buyers and their agents approach environmental due diligence? Answer: it creates a powerful incentive to conduct proper environmental assessments before purchase. Without documented due diligence, a buyer may lose the ability to claim innocent landowner status and could be liable for costly cleanup, even if they did not cause the contamination. Why is a home's proximity to a landfill, Superfund site, or heavily pesticide-treated property considered a material fact? Answer: such locations can affect health risks, financing, insurance, market value, and buyer decisions. Because a reasonable buyer would want to know about these conditions before purchasing, failure to disclose them can result in legal liability for the seller and licensee.